May I request everyone to please settle down? We'll just be starting in a minute. May I request everyone to please settle down? You're requested to remain seated when the session is on. Time permitting, we'll take breaks in between sessions. Please keep your handphones on silent mode throughout the program. Thank you for your cooperation. So namaste everyone. Let's begin by wishing each other a very happy Mahashivratri. Also to all the beautiful women and the ones who celebrate women, a very happy Women's Day. What happens when the state or entities owned or controlled by state enter into commercial agreements which contain an arbitration clause? Is it any different? Sure. For state-owned entities deal with public resources and hold such resources in public trust. The consequences of an adverse award may have larger ramifications. The right to challenge an adverse award, therefore, is of unique importance to such entities. At the same time, state-owned entities looking to attract investment from the private sector would want to assure their private partners that disputes, if any, will be resolved as quickly as possible and would not get into protracted litigation. Well, my dear friends, that's our first session today. I welcome all of you to day 3 of Delhi Arbitration Weekend. Our panel through this session will examine some of these unique issues which arise in arbitrations involving state-owned entities right from contract formation to its enforcement. They will provide an insight into the efforts that can be made by state-owned entities to address some of these issues and to ensure that their counterparts are not deprived of the benefits associated with arbitration. They will also consider the principle of attribution in arbitrations involving state-owned entities. May I have the honor of the chair and the speakers of this session to please come onto the stage. May we have a big round of applause. Our chair for the session is Honorable Mr. Justice Hrishikesh Roy. It is in the year 2019 when Justice Roy took oath as a judge of the Supreme Court. He served as the 35th Chief Justice of the High Court of Kerala since August 2018. Earlier on, in 2004, he was designated as senior advocate by the Guwahati High Court before being elevated as a judge of the Guwahati High Court. With him, we welcome our esteemed speakers. Though as such, this panel really needs no introduction. And I know all of you are eager to hear from them, so I'll keep the introduction really short. We have Honorable Mr. Justice Ramamoorthy, who's a judge of the High Court of Madras. He's enrolled as an advocate in 1990. In 1992, he obtained his master's law degree in constitutional and international law from the Madras Law College. He was also awarded a junior research fellowship in law by the UGC. Justice Ramamoorthy worked as a partner with a leading law firm and headed its Chennai office until his elevation to the bench. We also have with us Mr. Tushar Mehta, and I'm pleased to welcome him. He's the learned Solicitor General of India. We have also with us Mr. Pilbrow, King's Counsel, a highly regarded and well-established commercial silk with a broad commercial practice. He's a litigator and an advocate applying that expertise across the broad spectrum of commercial work in both litigation and arbitration. Next, please join me in welcoming Ms. Yen, Senior Counsel, who's the head of the International Arbitration Practice and a partner in the Commercial and Corporate Disputes and Commodities and International Trade Practices at the WongPartnership. With this, I request this chair to please take the discussion forward.
Uh, my household is a women-dominating household. We are parents of 2 daughters, and of course the wife is there. So I have to acknowledge the International Women's Day to everybody, male and female. Let us acknowledge the International Women's Day. And today's discussion, to take it forward, I'll have a few minutes of introductory remarks. We have a very distinguished panel, as has been introduced by Radhika, Justice Senthil, Mr. Tushar Mehta, the Solicitor General of India, then Mr. Fionn Pilbrow. I'm saying out the names so that I'm just trying to get the pronunciation right. And then Ms. Swee, I suppose I've got that right. And we also have the distinguished members of the bar, the sitting and former judges, the members of the fraternity of the field of arbitration. The topic today is State of Arbitration, Navigating an Arbitration Invoking State-owned Entities. Now, the foundation of arbitration lies, as you would know, in party autonomy. Parties opt for alternative dispute resolution mechanism for speedy, inexpensive, fair adjudication with minimal court's intervention. But when you have decided to choose arbitration, all stakeholders in the process, including the state entities, must understand and be prepared to follow the rules of arbitration. Even within arbitration, we have a huge distinction between what we may term as domestic arbitration or what is seen as the international arbitration. Then we also have a very different species altogether, the investment arbitration, which involves treaty interpretation and public international law. A study focusing on arbitration-allied orders of the Delhi High Court between the year 2007 and 2020 indicates that most challenges involve the National Highway Authority of India. Now, this is a pointer towards the state entities failing to respect arbitration award, which, as we know, is passed on by the voluntarily chosen arbitrator. On this, Justice Senthil is going to focus in part of his deliberation. In 2017, a Delhi High Court bench of Justice Geeta Mittal and Justice Harishankar, in a judgment, deprecated the public sector undertaking from challenging arbitral awards, opining that such attempts contribute to the menace of docket explosion. Dismissing the appeal with cause, the court noted that it is a matter of concern that the majority of such challenges are by public sector undertakings. We have the presence of the Solicitor General, Shri Tushar Mehta, and I'm sure he will focus his attention in part of his deliberations towards this aspect. To address the concern, the government has recently devised a new 2-tier mechanism of arbitration for PSU disputes, replacing the permanent machinery and the one-time settlement scheme Vivad Se Vishwas 2 for contractual disputes. I'm sure Mr. Mehta will have occasion to touch upon. Another thing that is very significant when you look at the PSUs finding themselves in tight spot is that they often seek escape route by saying that they are an organ of the state and taxpayers' money is involved. In an international context, this is a very slippery slope argument. In the world of commerce, everyone expects a level playing field. When a PSU claims that public money or taxpayers' money is involved, it has the potential to expose the Indian state and the government assets in certain contingencies. So this is something which is a matter of concern. If we specifically look at the arena of international arbitration, everything will seem different. The art of advocacy, the evidentiary process, the use of experts and discovery, tailor-made soft laws, and the tools deployed may all be new for the uninitiated. If you don't know the rules of the game, you are not likely to be on the winning side. So the state entities need to make sure that they have onboarded at least one person on the team who is familiar with the regime of international arbitration. We must understand that it's a different ballgame altogether. To explain what I wish to emphasize, let me borrow an analogy from the game of poker. I do not know how many of you are familiar with the game of poker. Anyone here? Okay, I see some hands being raised. Okay. Now, in poker, which many believe to be a game of skill and with chance as well, now a pot is kept where the stakes are placed by the players before the game starts. This pot in the poker game is also known by the name ante. So in the context of international arbitration, the state-owned entities must up their ante. This is what I want to focus on. When you are in the esoteric arena of international arbitration, you have to match the best in the world. In India, we still have the system of litigators taking up arbitration work as part-time profession. I was speaking to Mr. Pilbrow, who said that he does litigation and also arbitration, but mostly in the field of commercial law. So we also have lawyers who are largely in the field of litigation, going to courts and also attending to arbitration work. Now, obviously somebody who is devoting exclusively to the field of arbitration, he is better prepared. He knows the subject much better and is more capable and competent. So therefore, the syndrome of moonlighting at some stage may have to stop. Or we may, of course, the lawyers, they have to go for normal legal litigation work in order to earn a name as a lawyer, in order to name for themselves as a counsel. So that is also equally relevant. But at some point of time, some of us or some of you may focus, at least the young people, exclusively in the field of arbitration. Now a caveat for foreign entities who choose to do business in India. You must get a good understanding of the working of the state entities. Please remember that in India, the state is the largest litigator. And there's a reason for this. As you know, the state is driven by rules which can often slip into being driven by fear. The fear of being questioned sooner or later by any one of the multiple watch at situations somewhat cynically and from a very different perspective than, say, that of a businessman. This leads to a flawed decision making. This is more visible where the stakes are high. In a high financial investment situation, the decision maker is likely to say, litigate the matter until exhaustion of the last possible legal remedy instead of taking a decision. The reason, of course, are not far to see. Here, let me borrow another analogy from the game of poker, where a marker is placed in front of the person to indicate whose turn it is now to deal. For those familiar with the genre of popularly known as cowboy films, a marker in a game of poker could be a buckhorn knife, those the cowboys used to carry in those days. So the expression that you are familiar now emerges. The buck stops here. In a public sector undertaking, it is often a game of passing the buck. The buck is passed because people who are expected to take responsibility fear to take a call. It is because decision taken today to concede a legitimate claim or to accept a fair award could be a subject matter of scrutiny many years down the line, even though the arbitral awards do not have a presidential value. So the safest strategy is to challenge the arbitral award so that responsibility is passed on to the court's eventual decision. One impact of such syndrome is the general inability of the state entities to settle disputes, especially where the stakes are substantial. One may recall the Union Carbide case pertaining to the Bhopal gas tragedy, where 5 judges of the Supreme Court had to step in the interest of the victims to facilitate a settlement. As is noticed very often, despite best efforts, including ongoing efforts, the state has not been able to put together a system to facilitate mediation and arbitration. This is not good for our nation and has wider ramification impacting the goal of ease of doing business in India. It is essential to build capacity and educate every stakeholder of the government to understand the special risk of, in the context of investment treaty arbitration, for instance. There is also a need for better coordination between different ministries, including developing a robust litigation strategy. To arrest the tendency of passing on the buck, it would require the Indian government to urgently devise and notify a process which will facilitate not only responsive decision-making, but would also protect bona fide decision when taken by such chosen entity. As some of you are familiar, the Indian government has constituted recently an expert committee chaired by Dr. T.K. Viswanathan, and the committee has, as recently as on 7th February 2024, made certain recommendations. Some of those are, this is for the government to challenge in the recently given recommendation by the Viswanathan committee. Number 1, challenging an arbitral award, which has little scope for success in most cases, expose party challenging the award to an additional interest burden until the challenge is finally decided. This has to be borne in mind. Secondly, any decision to challenge an arbitral award must be based on an honest assessment about the prospects of success as weighed against the estimated cost of litigation, including the escalating interest burden. The legal person involved in the arbitral process must identify the grounds of challenge and make a realistic and reasonable assessment of the prospect of success. This may be supervised a senior level officer. Periodic reviews, particularly on the outcome of challenges to arbitral awards, must be carried out. Simultaneously, the government may consider initiating discussion with the successful party to explore the possibility of settlement. More often than not, the successful party may be willing to give up some of the awarded amount to avoid the risk of uncertainty arising of dependency of the challenge to the award. A hybrid mediation arbitration process could also be adopted to resolve disputes. Larger policy changes will have to come from the government itself, while the changes in the law can help fix standards and address the problems of delays and costs to some extent. There's an urgent need to minimize the challenge to arbitration awards. This entails fostering of greater appreciation for arbitration as a robust alternate dispute resolution mechanism and recognizing the importance of finality to arbitration awards. In an impressive gathering of international experts and players in the domestic field such as this is a valuable opportunity for the exchange of ideas and to learn from experience across the nation's borders. As I said earlier, to navigate arbitration, particularly in a high-stake matter or international arbitration or investment arbitration, which involves treaty interpretation and public international law, you have to learn and master the rules of the game. And then you have to play the game better than your opponent. This is very crucial. So the only way to go forward is that the stakeholders must, going back to my original theme of the poker game, the stakeholders must up their ante and also send out a strong message from the desk of the decision maker that buck stops here. Thank you.
May I now request Honorable Justice Ramamoorthy to please come on to the dais and share his thoughts.
Justice Hrishikesh Roy, my fellow panelists, judges of the Delhi High Court, advocates from India and from other parts of the world. Ladies and gentlemen, at the outset, I must thank the organizers for inviting me to participate in this event. I propose to deal with domestic arbitration because we have two speakers on the panel who will be dealing with international foreign-seated arbitration. In domestic arbitration, again, I intend to speak briefly about infrastructure and construction arbitration. And the reason I'm focusing on that is in domestic arbitration, from my experience both as advocate and judge, the two largest categories would be finance-related arbitration, which is essentially non-banking financial institution-driven arbitration, and construction arbitration. And given that our topic is navigating arbitration with state-owned entities, a lot of it is in the arena of infrastructure and construction arbitration. Now, this process, we tend to typically focus largely on what happens in court when court intervention is sought for under sections 34 or 37, as the case may be, and on enforcement. But really, it all starts with contract formation. And then, from contract formation, you have a phase of actual performance of the contract management. And then you have the pre-arbitration phase when a dispute is already commenced and parties are trying to sort it out. From there, you move to the arbitration phase, then the court enforcement phase. So, I think that too much attention has been paid to the court intervention phase. So I would like to actually begin with the contract formation phase because I think a lot of the problems associated with arbitration involving state entities, turns on contract formation phase. Typically, in the domestic arbitration contract, you will have two types of contracts. You have a whole category of contracts where, the state-owned entity has the general conditions of contract, and this is pretty much, a take it or leave it kind of contract where there's little or no scope for negotiation. You will have a special conditions of contract where there is limited scope for negotiation. You have statement of agreed variations typically, and there is reasonable scope for negotiation. So in this category, I would say that often the trouble is that the contracting state entity, inserts clauses which makes it very difficult for the private counterparty to, make claims subsequently. And that is one of the reasons why, you have a lot of litigation. Now, a lot of this, it, revolves around about 5 or 6 different types of, issues that arise. I would say, one of the issues which commonly arises relates to additional work. a lot of the time what happens is that at the contract formation stage, the parties don't sufficiently prioritize the fact that it's impossible to properly anticipate the scope of work. So, they don't provide for the approval process for additional work. They don't provide for a mechanism for deciding on the rates for additional work. So subsequently what happens is you have a situation where the state entity either does not grant final approval at all for the additional work, or even if they grant approval for the additional work, they don't approve the rates relating to the final work. So this is a problem that clearly has to be fixed at the contract formation stage, and it's quite difficult to fix subsequently. The second issue, which typically arises particularly with state-owned entities, is the work gets disrupted or prolonged for multiple reasons. One is that the site itself is not available, or the site is available, but the site is available only in parts. So this results typically in disruption. Now the private counterparty would have brought in the machinery, the labor would have been mobilized. It'll be at site, but they'll be unable to start. Sometimes it's not even because of availability of site, but it's because of lack of certain approvals. And these are the two biggest factors behind, the commencement of the project being delayed. And if this is not properly dealt with in the contract documents, it again becomes very difficult to remedy the situation subsequently, and it results in claims either for disruption or claims for prolongation of the contract. And again, you would find that one of the big challenges is that in the contract documents, at least in the domestic context, I find that parties don't identify the critical path. Now, for those of you who are not familiar with it, it's obviously the activities which have to be carried out in sequence, so that you have an idea of what is the shortest time it would take to execute work. And again, because this critical path is not properly identified, what tends to happen at the subsequent stages is that parties put together all the events of delay. There could be hundreds of events of delay in an infrastructure or construction contract. Many of these events would be events that happen concurrently. Therefore, strictly speaking, they should not be reckoned in delay analysis. But because the critical path is not identified, and because the critical path is not analyzed while the contract is being performed, you have a holy mess when the arbitration is conducted, or when the case reaches the High Court, or even all the way to the Supreme Court, where parties have merely placed on record evidence relating to hundreds of delay events, and then claims are being made on this basis. So I would say that this is something that has to be addressed at the second stage, which is really the stage of contract management. If at the contract management stage, proper critical path analysis is done, and it is done on an as impacted basis, then precisely which delay event caused how much delay and how much did it impact the critical path. You will also be fairly clear as to the attribution of this delay. Is it attributable to the employer, the state-owned entity? Is it attributable to the contractor? Now, without undertaking this process, I find that, both at the arbitration stage and subsequently at the court intervention stage 34, 37, or even in the Supreme Court, it becomes impossible to actually ascertain as to how much the delay events impacted the project Therefore, how much should be paid by way of compensation? Instead, what I find is that typically, parties come up with, let's say the Hudson's formula or the Ickley formula or the Ebden formula to compute delay, because they've actually not gone through a systematic process of evaluating delay and the impact of delay. And at the contract management phase, what I've also noticed is that generally the documentation, be it on the part of the state-owned entity or on the part of the private contractor, they don't maintain documentation relating to disruption. They don't maintain proper documentation relating to even, the delays that happen due to prolongation of the contract. And therefore, evidence is not placed before the tribunal. Much of the time, advocates come into the process at the arbitration stage, and then you don't have adequate evidence either to establish the compensation claim for disruption or the compensation claim relating to prolongation. And this results in, cases being, the arbitral tribunal takes a certain decision, and then the High Court in 34 looks at the evidence and finds the evidence is irrelevant. Oftentimes I've seen that, for instance, a party is complaining about disruption, but the evidence that's placed before the High Court has to do with the prolonged period of the contract. It has nothing to do with the disruption period of the contract. So these are issues that play out particularly in this context. I would say that likewise, what tends to happen is that, these projects tend to be long-term. Even EPC contracts often run for 3 to 5 years. If you are looking at, infrastructure contracts which are done on let's say on a BOT basis, then, you're looking at sometimes even a 30-year concession period. So over this long duration, you are likely to see changes in law. And once again, I find that at the contract formation stage, change in law is not, anticipated clearly. It's not defined clearly. So because of that, again, you have a lot of cases that travel all the way to the Supreme Court. I mean, we've had cases like, for example, PSA Sikals was decided by the Supreme Court on a change in law. And these are cases where, decisions of the tribunal get reversed because parties have not defined change in law widely enough. Similarly, you see in the context of even something like, let's say, escalation. Now, obviously, over the lifetime of a contract, which runs for multiple years, the prices of materials, the prices of labor, all of which is going to undergo changes. Usually, it escalates. So you typically provide for it in the form of a price variation clause. Now, again, the law on the subject in India, if the contract prohibits, you cannot grant escalation. If the contract is silent, you can grant escalation. Now, on what basis do you grant it? Obviously, the contract has to prescribe the formula on which you decide on escalation. And there can be so many issues relating to this formula. For instance, most of you would know the judgment of the Supreme Court in Sangyong. Now, it's a celebrated judgment on the scope of Section 34, particularly after, the Amendment Act 3 of 2016. But what one doesn't normally pay much attention to is in that case, there was an escalation or price variation clause. Now, the price variation clause was based on the 1993-94 series of a particular index. They stopped publishing that index by the time the contract was performed. So then, perforce, what happened was the current series was adopted by the arbitral tribunal. And for adopting the current series, they had to use a linking factor. Eventually, when the case traveled to the Supreme Court, the majority award had accepted the use of the latest series with the linking factor. Supreme Court felt that that was completely, extraneous to the contract. So then the Supreme Court, it was one of those rare cases where the Supreme Court actually applied the minority award and made the minority award as the majority award by setting aside the majority award. But again, it shows that if at the contract formation stage, you don't foresee the fact that, over the duration of the contract, that these changes are going to occur and you don't build in that flexibility, it becomes particularly difficult to deal with the situation. If it were a private counterparty, chances are that both parties would be sufficiently flexible to, probably sit across the table and negotiate in a situation like this. For good reasons, a government entity is not in a position to do that. It has to be necessarily document-driven because you are dealing with public resources. You are dealing with public money. So that is, I would say, the biggest difference between dealing with, a private counterparty and dealing with a state-owned entity. It simply means that, therefore, you have to attach greater importance to the contract formation stage, the contract management stage, so that you anticipate all these contingencies better. And then, you are in a position to deal with all these contingencies. So with these few words, I will stop here because, the other panelists are going to focus on enforcement. All I will say is that at the enforcement stage, in many ways, I would say that one is better off dealing with state-owned entities because at least, there's less likelihood of bankruptcy and those kind of issues. Thank you very much.
Thank you, sir. May I now request the learned solicitor to please address the gathering.
A very good morning to all of you. Justice Roy, Justice Senthil Ramamoorthy, my co-panelists and dignitaries of the dais. Taking clue from my Lord Justice Roy, I wish everyone a very happy Women's Day. And it is said that a woman who aspires to be equal to man lacks ambition. Because they are already above, they are already superior to them. Coming to the subject is very specific, and the specific is that it is not arbitration in general, but arbitration with regard to state-owned entities have their own inbuilt problems. Some problems may have some legislative solutions. Some problems may have some administrative solutions. What happens typically is that, as Justice Senthil Ramamoorthy said, that much attention is not paid at the time of drafting of the contract to drafting of the arbitration mechanism. Minute details are going into as to how the contract would operate, contract would work, etc., how the damages would be paid, who will be responsible for which part of the contract. When it comes to the arbitral clause, much attention is not paid, thinking as to what would happen 5 years down the line, 7 years down the line. That is the first problem which is encountered when the dispute arises. Second, some of you might be aware and many of you might be surprised to know the real problem which is faced by the state-owned entities, especially in construction contracts and infrastructural contracts. We have certain big companies in the field of construction and infrastructure, and it might sound a little odd, but their main source of income is arbitral awards. And I mean every word of it. What they do is, they give the bid which is unbelievably high. It is impossible for any state-owned entity to take the risk of rejecting the bid. Thereafter, from day one, they will start the correspondence in such a fashion, keeping the future arbitration in mind, and it would result into the arbitration running into thousands of crores. That is the first problem for which there appears to be no solution, and why I am addressing this issue in this August gathering is because of my concern that many state-owned entities, public sector undertakings, are seriously taking a call of not providing for an arbitration clause in their respective contracts. This is something very, very serious. What is the reason behind it? The reason is, and I am expressing the views of the public sector undertakings. These are their views, not views of the government, may not necessarily be the views of the government. They feel that under the present regime of the arbitration law in India and substantially in other parts of the world, for all intent and purposes, the arbitral award is last and final word. Because the contours, the parameters of challenge, for example, in Section 34, in the Indian context, are so narrow that it's virtually impossible to bring the case within the very, very narrow scope of Section 34 of Indian Act and corresponding provisions of other acts. There is a growing feeling, and at that destination, there may be some legislative thinking required. Can we have at least one right of appeal? Only one. That might inspire confidence, maybe with some time schedule, maybe with some conditions, maybe with condition of depositing the amount, or whichever condition which may ensure that at the drop of the hat, the person doesn't invoke the remedy of appeal. This is a thought process which is going on amongst major public sector undertakings, that what we in this function call state-owned entities. That's the second problem. Third problem is availability of good and dependable arbitrators. And when I say that, I mean both the adjectives in every sense of the term. I leave it at that. But there is no level playing field so far as a state-of-owned entity, or rather public sector undertaking, and a private entity is concerned. There is no level playing field, and we experience that lack of level playing field when we actually go for arbitration. But nonetheless, despite all problems, the government of India is fully committed to encourage arbitration as the most effective alternative dispute resolution mechanism. There are broadly two categories in which the arbitration is being encouraged by the government. Number one, in case of state-owned entities or public sector undertakings, there is a circular, most of you would be aware, that whenever there is a challenge under Section 34 of the Act, in case of construction contracts, there is a mandate that 70% amount will have to be deposited. That works two ways. A, it disincentivizes the entity from filing frivolous challenges. And second, it ensures the faith in the system even so far as the other side is concerned. Second, as my Lord Justice Roy flagged, now we have a Vivad se Vishwas scheme. Vivad means dispute and Vishwas means trust. From dispute to trust. There the scheme is, it is divided in several parts in terms of the monetary impact of the award. If the award is less than certain figure which is prescribed, say 100 crores, then it is mandatory for the state-owned entity to settle the dispute by offering 60% of the arbitral award. But while representing one section, namely the public sector undertaking, there is heartburning we have come across cases where there are extraordinary chances of succeeding in 34, but Vivad Se Viswas mandates a settlement at 60% or 70%, depending upon what is the amount involved in the arbitral award. That is something at an administrative level, at an executive level, and at collective level of people who are involved in the process, government may consider deciding. Yes, as Justice Roy mentioned, there is a committee. The committee's report has come. The report, prima facie, the general perception is too general in nature that a person has to be very, very careful while deciding to challenge the arbitral award, which in absence of that recommendation also, everyone will have to be careful. But one thing is very clear, and as a representative of the government, I can assure this House that there is not a slightest intention on part of the government to dilute the mandate of the arbitration law. If we go by the Act, there are threefold mandates: A, party autonomy; B, limited challenge; and C, immediate enforcement. There are certain hiccups, there are certain issues specific to the public sector undertakings, and there can be a possibility, I'm not saying there is a possibility, there can be a possibility of some wider discussion to ensure that we provide a system which is so foolproof and which is so trustworthy that the public sector undertaking would not feel need or would not feel compelled to challenge. Lastly, why, even in genuine cases of a good arbitral award, the challenges come? The reason is obvious. In case of private entities, there would be one decision maker or few decision makers, and the buck would stop there. They are in a position to take the call. They are in a position to take the final call. In case of public sector undertakings, the officials are floating population. They are here today. They may be somewhere else tomorrow. The decision making is always a collective decision making. And the hanging thread of some action being taken for one decision being taken one way or the other is also a disincentive to take a call, and therefore, rather they are on the safer side of ending up challenging it. For that, if there is an internal mechanism within all public sector undertakings, say, 3 members of the board of directors being authorized by the board of directors to take a call, and the buck should stop there, with a provision of post facto approval of their decision not to challenge an arbitral award or not to challenge an arbitral award after a particular stage. Say, for example, you take a chance in 34. Maybe the expression is not correct. Maybe you approach a 34 court and thereafter you take a call that now henceforth no further proceedings to be undertaken. And there has to be an inbuilt system to insulate the decision makers for any future change of mind by the future management. These are some discussions which are going on at the internal level so as to ensure that the arbitration, which is otherwise the product of the Indian thought, arbitration as a codified statute law may have come now before 50, 60, 70 years. But in our Indian system of dispute resolution, arbitration had always been there since thousands of years. Now we have codified it. Now we have provided for the challenges. Now we have defined them. Now the challenges are also definable. So the government of India is committed to ensure that this codified form of the traditional system of dispute resolution in India is not diluted while taking care of genuine concerns of the state-owned entities. This is all I can say, and this is all I had to say. Thank you so much. Good day.
Thank you so much, sir, for bringing out the issues related to state-owned entities. Now, may I call upon Mr. Pilbrow to please share his introductory remarks.
Good morning, everybody. I will certainly follow those that have gone before me by expressing my great pleasure at being here in Delhi for this conference, and what an honour it is to be part of such an august panel as I've been allowed to join this morning. My approach will obviously be different from Justice Ramamoorthy's and the learned Solicitor General's, because I approach this from the point of view of an advocate used to appearing for and against state-owned entities in international arbitration, in investment treaty arbitration. And when one is fighting an arbitration for or against a state-owned entity, there are specific issues that arise from the fact that state-owned entity is involved at every stage of that process, from every stage of the life cycle of an arbitration agreement and of an arbitration itself. So, for example, when a dispute arises, experience tells one that there are likely to be issues that arise in connection with the appointment of arbitrators, the arbitral process when it is underway, so securing document production, securing witness evidence, managing the mechanics of that process, issues as to how one can settle or mediate disputes, all the way through to enforcement and issues arising in connection with applications to set aside. So why do such specific issues arise? Well, part of it is simply just the fact that one is acting on behalf of or against a state entity. And many commercial counterparties will be resistant to the notion that they can act against that entity within the courts of the state in question. And many of the practical issues that arise from the fact that, while on the face of it, state-owned entities are just commercial entities, the reality is that they do not operate in the same way. And Justice Roy has alluded to that with his phrase, which absolutely hits the nail on the head here, about the buck being passed conventionally in those sorts of entities, the difficulty in securing rapid and precise decision-making. So that, for the advocate and for those conducting the litigation, presents problems in, for example, obtaining instructions, obtaining clear and quick instructions, securing compliance with document production orders and witness evidence orders, securing clear authority for the purposes of settlement negotiations or mediation discussions. And that can play through in lots of ways. I know from my own experience, and I know I'm not alone in my chambers of this view, that if you're acting for a state-owned entity and you're thinking about the selection of an arbitrator, you might be tempted to look at someone with experience, relevant experience, someone that's dealt with state-owned entities themselves, or, if you don't have that, you're more likely, in my experience, to try and select someone still in practice, a practicing advocate as your arbitrator, rather than a retired judge, because that person, still being in practice, is just that bit closer to the coalface, just that bit closer to the real-life experience, and therefore probably remembers and knows what it's like trying to deal with a state-owned entity, and may have a little bit more sympathy with a party that's struggling to meet deadlines, that's struggling to obtain instructions, rather than a judge who's been out of practice for a while, and therefore is further from the coalface. So there are lots of ways on which just and I'm sure all of those points will come up more in the Q&A. I've so far identified a lot of things and that is the question. So when someone has you're likely to have a direct claim, order's claim against the entity, but it may be, for whatever reason, for example, the dispute resolution mechanism in your contract with that entity, which may prescribe for a resolution within the courts of the country, which you may not fancy, you may be thinking, that claim's not attractive. So you'll want to think in that situation about whether the acts or omissions of the state-owned entity can be attributed to the state in question, so as to be able to think about an investment treaty claim. And in that context, that's what I wanted to focus on for my short little moment this morning, and to look at the general principles of attribution, and to look at one recent award, a 2023 award from last year, that demonstrates the application of those principles. So, Chapter 2 of the International Law Commission's Draft Articles on Responsibility of States for Internationally Wrongful Acts addresses attribution. And it sets out a number of gateways by which different forms of conduct can be attributed to the state. And the most relevant, the most likely, are Articles 4, 5, and 8 of those draft articles. Now, I did have some slides prepared which would have allowed you to see those articles, but having been here through yesterday's talks, I saw that no one else used slides, so I've not bothered with that, but they're always available if anyone would like to have them. I can always forward them on to anyone. So let me just tell you about them instead. So Article 4, it deals with the conduct of organs of the state, and organs of the state are to be attributed to the state. So the inquiry here under Article 4 is as to the function and nature of the relevant actor, rather than under the circumstance of the impugned conduct itself. And so that extends to both de jure and de facto organs of the state. Articles 5 and 8 deal with the conduct of non-state entities, but prescribes when their conduct is attributable to the state nonetheless. And that is when the person or entity is empowered under domestic law to exercise governmental authority, that's Article 5, or when the person or entity acts on the instructions of or under the direction or control of the state, that's Article 8. Now, there are obviously textbooks out there that can tell you about this, and you can go and research it. But there's a case from last year, a case called Mobile Telesystems, MTS, and Turkmenistan, that illustrates quite a few of these principles. So I was just going to pick up that case and focus on it for a moment. So that claim was brought under the 2010 Russia-Turkmenistan Bilateral Investment Treaty and conducted under the ICSID Additional Facility Rules. The claimant in that case, MTS, was a Russian company that had made investments in Turkmenistan telecommunications market. And it had entered into various commercial agreements with various Turkmen entities, which had secured it access to Turkmenistan's cellular communication infrastructure, dealing with, in particular, Turkmen Telecom, which was a wholly owned subsidiary of Turkmen Ministry of Communication, and also a company called Altin Azir, which was a Turkmen mobile network provider, which was owned 89% by Turkmen Telecom and 10% by the Ministry of Communication. And you'll all have spotted that that leaves a missing 1%, and the award doesn't make clear who owned that. So that's just one of those mysteries. But the question that we're going to focus on briefly is the question of whether, and the tribunal acknowledged this, obviously you, claimant, have contractual claims against Turkmen Telecom, but do you have an investment treaty claim? And that depends on whether these acts and omissions are attributable to the state. And so they broke that down, their analysis, and took it step by step. So considering first the actions of the Turkmen Ministry of Communications and the Cabinet of Ministers, that was pretty easy. The tribunal says, yes, of course, the actions of the Ministry of Communications and the Cabinet of Ministers, those are attributable to the state under Article 4. They are de jure organs of the state. That was easy. So then you have to come on to consider Turkmen Telecom and Altin Azir, the two commercial entities. So, Turkmen Telecom. They found that Turkmen Telecom was a de facto state organ because it performed governmental functions and therefore its conduct was attributable to the state. I won't go through all the reasons of that, but essentially they look at its establishment, its operation, and how it held itself out and conducted itself in business to conclude that it was a de facto state organ under Article 4. They also considered the actions of Turkmen Telecom under Article 5 and decided that it was exercising governmental authority. That's because it controlled and allocated the data channel capacity, so if you wanted to get access to the network, it had to be through them. And it entered the agreements pursuant to specific governmental directives, specific governmental authority. So Turkmen Telecom, under either Article 4 or Article 5, is an organ of the state and its acts are attributable. The contrast one gets is with Altin Azir. So Altin Azir is essentially 100% owned by the state, but it was not a de facto state entity, and it did not exercise governmental authority under Articles 4 or 5. And the tribunal reasoned in this regard that it was owned and controlled indirectly by the Ministry of Communication, but that was not determinative. Rather, it was, and the tribunal says, first and foremost a commercial company and a competitor in the telecommunications market. So it did not exercise regulatory functions, and so it was not an Article 4 or Article 5 state-owned entity, state-controlled entity. So it went on to consider under Article 8, and this is the difference, on the basis whether it acted under the instructions, direction or control of the Turkmen state. And it concluded that its acts could not be attributed to the Turkmen state. The fact that it was wholly state-owned and the fact that it had independent legal personalities, those were just indications of general control, indicators pointing in opposite directions, but only general control. And that's not enough for Article 8 purposes. Rather, what you need for Article 8 purposes is evidence of specific control over the particular conduct in question. And there was, in this case, no evidence that Altin Azir had been acting under specific instruction, direction, control, in relation to the specific conduct, the provision of insufficient interconnection channels to the claimant. So Altin Azir was not found to be, its conduct was not found to be attributable to the state. So what does this award tell us? What lessons are there for us when we're thinking about the position with a state-owned entity of whether one has an investment treaty claim? It tells us, number one, that ownership is not determinative. The fact that an entity is state-owned doesn't answer the question on its own. Turkmen Telecom was state-owned, but Altin Azir was also state-owned, and that was not found to be attributable. Second lesson we take from it. The question of whether conduct is to be attributed can be highly fact-dependent and specific. And the nature of the factual inquiry differs depending on one's thinking of an Article 4, Article 5, Article 8 question. And you have to, if you're the claimant in that situation, put forward evidence to make good your position on attribution. And that's demonstrated by the failure of the claimant, MTS, to persuade the tribunal that Altin Azir performed a regulatory function, or that its conduct was specifically controlled by the state. And third lesson, probably, and stepping back to consider the overarching theme of this session, a conclusion that a state-owned entity's conduct is not attributable to the state is not the end of the road. It simply means you don't have an investment treaty claim, so you're left thinking, all right, well, what is my remaining claim? Do I have an international arbitration claim? Do I have a claim in the courts of the jurisdiction in question? You may have a claim for breach of conduct, you may have a breach of contract or tortious claim. But the very fact that you've gone through that analysis, thinking about the investment treaty claim, may tell you that you didn't fancy your other option, but that other option is still there. So that was what I was going to say briefly about attribution in this context. There's obviously an awful lot one can talk about in relation to state-owned entities, and I know Ms. Coe is going to talk about enforcement, and I'm quite sure in the question and answer session we shall come on to some of the practical problems as well. Thank you.
Thank you, Finn, for sharing your thoughts. May I now have Ms. Yen to please share her remarks.
Thank you. Justice Roy, Solicitor General Mr. Mehta, Justice Senthilkumar, distinguished judges, ladies and gentlemen. I wish to first express thanks to the organizing committee for inviting me to Delhi. Such amazing weather, warm hospitality, delicious cuisine. Anyone who's been spending time with me over breakfast would know that I've constantly been asking for the Delhi breakfast. I'm very happy to see many familiar faces in this crowd from the international arbitration community, those that are both based here in Delhi, based here in India, as well as who have come from abroad to attend Delhi Arbitration Weekend. I am gratified that through this past 2 days, I've met many new friends and have many good interactions. Happy International Women's Day, and I think it's a day that all of us celebrate. And thanks to you for being here on a public holiday in Delhi. As the last speaker on this panel, and you've heard from the three wonderful speakers and our moderator, Justice Roy, I have an extremely tough act to follow, and I think they did this deliberately to me. I did not know until now that I'll be the last speaker. So let me try my best to continue to keep you with me and keep you entertained. We have a very fascinating topic today, navigating an arbitration involving state-owned entities. You would have heard from the earlier speakers that you need to appreciate the peculiarities of a state-owned entity. You need to consider issues, like Justice Senthilkumar said, at the time of contracting. And at the time of contracting, you also need to consider, when you have an arbitration clause, what is the arbitral seat you would choose? And when one contracts with a state-owned entity, as a foreign investor, you would often be looking for that neutral seat and that seat that is not in the national courts. And indeed, I have had the chance to see various state-owned entity contracts, India's state-owned entity, or they are more commonly known as public sector undertakings. And when I look at the provisions of these contracts, often they would have an arbitration, arbitral institution, SIAC, ICC, with a seat either Dubai, Singapore, or London for the parties to agree. We also look at the applicable law, and I think in that negotiation, applicable law, parties would try again to ask for an applicable law which is known, certain, neutral, sometimes English law, sometimes Singapore law, and they may refrain from choosing the law of the state-owned entity. So we must bear these considerations in mind when we talk about the time of contracting. It doesn't end there. It goes to the time when the contract was being performed, another topic that the speakers have earlier touched on. It goes to the arbitral process when the dispute is brewing and you start the arbitration process and you choose and you think, who are the best arbitrators for the case? Mr. Pilbrow, he touched on the fact that you will be looking at perhaps private arbitration practitioners. The idea is that we all have an association that the state-owned entity is associated with the state. So as best as possible, let's move it as far as possible from any factor related to the state. Composition, the arbitration process. So many different facades and facets that you must consider. And what I'm going to focus on, being the last speaker, I thought, is at the end of the arbitration process. When you, after going through an arduous arbitration process, have obtained an arbitral award against a state-owned entity, what are the issues that you may potentially face in the enforcement and execution of this arbitral award? And that is really what I would like to touch on. Because at the end of the day, what is the most important is not a paper award, and we all know all paper judgment. It is to turn this into real monetary benefit for the client. So when we talk about the enforcement and execution of an arbitral award against a state-owned entity, what are the immediate questions that first come to mind? First, can a state-owned entity assert immunity against enforcement and execution of an arbitral award? If one manages to cross the test of attribution, which Fionn had touched on earlier, and say that the state-owned entity is actually an organ of the state, if that threshold was crossed, would it not then follow that the state-owned entity can then say, while you have a positive and an arbitral award against me, this is actually immune against execution? Let me try to give you the answer to this complex question. The doctrine of state immunity is one which is unique to each jurisdiction. While there is a concept of the international law of state immunity, it is up to each enforcement court to apply its applicable rules on state immunity. Increasingly, we see a convergence of international consensus on this, where instead of an absolute doctrine of state immunity, which means a state is absolutely immune to proceedings, immune to execution, that is known as the absolute doctrine, increasingly the international consensus has moved towards what is known as a restrictive doctrine of state immunity. So a state is immune only with regards to acts which involve an exercise of a sovereign power. This restrictive doctrine of state immunity is something which would be very familiar to those of you from the United Kingdom, Singapore, because we have a very similar legislative provisions. But actually, from my limited research, and many of you here are very much more well-versed than me, also found in Section 86 of the Code of Civil Procedure in India, where I think the consensus even within India is that it's not an absolute doctrine, but restrictive doctrine. And some of you may also know that China, which has always adopted an absolute doctrine of state immunity, has now amended its law with effect from 1st January 2024, where they likewise move along this international consensus of restrictive doctrine of state immunity. That being the case, when a state-owned entity engages in commercial activities and even it crosses the threshold of organ of state, can a state-owned entity then say, my assets are immune from execution? This question, complex as it sounds, I think, based on the case law and international jurisprudence, would be answered with most likely not. Most likely not is a good answer. Like what Solicitor General said earlier, Mr. Mehta, he said that, the state-owned entity will be there and will respect that arbitral award. So why do I say that it is very difficult for a state-owned entity to assert any doctrine or any doctrine of sovereign immunity? This is as follows. A state-owned entity as itself, one would know, is a separate entity. Being a separate entity prima facie, it is distinct from the executive organs of the government of state, and it is capable of suing when being sued in its own name. Generally, when we look across the jurisprudence and we look at the key cases, it has always been respected that many states these days are sophisticated and they deliberately construct and they incorporate state-owned entities to take on various commercial projects and take on various key roles. And while they may be for the public interest, the idea behind this is truly to insulate and to ensure that there's this separate entity. Which is why in a very recent case of Clevis Securities and others, and Hussein and others, there was an argument that was made by Hybrid Investment where it sought to dispute the court's jurisdiction, and this is an English High Court case, by saying that we are an entity that is owned by the Islamic Republic of Pakistan and not distinct from the executive organs of the government of the state. Furthermore, we would be deemed to be property of the State Bank of Pakistan. This was a case where an entity actually went to the courts to say, you have no jurisdiction over me because I am owned by Pakistan, I am an executive organ of Pakistan, and I am property of the State Bank of Pakistan. This argument was not accepted, not just for the sake that there was no evidence in support of it, but more critically, they cited Section 14 of the UK State Immunity Act, where they recognized the concept that an entity, when separately incorporated, is prima facie distinct from the executive organs of the government of the state, capable of suing or being sued. And the only exceptions in which they can assert this immunity is if they can cross the threshold and show that the proceedings relate to anything done by it in the exercise of sovereign authority, and the circumstances are such that a state would have been shown immune. That, you can see, is extremely challenging. Just take, for example, an Indian state-owned entity that's responsible for building the corridor, GMR. Would you be able to say that they themselves, in entering into all these contracts with the foreign parties, they are exercising sovereign authority? No, it is hard to reach that threshold because at the end of the day, they're entering into commercial contracts, awarding contracts to private contractors. So in the context of the Clevis case, what is extremely important, and I think is a case that everyone should know of and be familiar with whenever they are dealing with states and state-owned entities, is the case of La General and FG Hemisphere. And this is what many of you, if you deal in the state and state-owned entity space, would be very familiar with. I call upon you to read this case because this case specifically deals with this question of the position of state-owned corporation and the circumstances in which any and their assets may be equated with the state and its assets. You must see this as something that is extremely important. It is important because once you equate and you are able to cross the test to equate a state-owned entity with a state assets, what happens? If you can equate a state-owned entity with a state, it means that with an arbitral award against a state-owned entity, you can enforce against the state's assets. Let's look at it in the converse. Likewise, if you have an award against a state, and you can say that this state-owned entity is effectively an organ of a state, a case that Fionn had touched on, you can then enforce an arbitral award against a state, against the assets of the state-owned entity. So the FG Hemisphere test is the test that has been adopted generally in the common law jurisdiction. There's no reported judgment in Singapore as to whether we would adopt this same test. But essentially, it deals with the very important question as to, can a state-owned entity be held liable for a state debt? Conversely, can a state be liable for the state-owned entity's debts? And I just want to touch on a few points in this judgment and leave you to read it at your leisure. Bedtime reading. Not Netflix, but read this case. What then is the key question they ask? What is the correct approach to distinguish between an organ of a state and a separate legal entity? This very important question, we must all bear in mind, is relevant not just to immunity, which I touched on. It's the question of substantive liability, which is attribution that Fionn spoke about, and enforcement. And the court said, and I'll cite from a few lines, separate juridical status is not conclusive. An entity's constitution, control, and functions remain relevant. But constitutional and factual control and the exercise of sovereign functions do not, without more, convert a separate entity into an organ of the state, especially where a separate juridical entity is formed by the state for what are on the face of it commercial or industrial purposes with its own management, own budget. The very strong presumption is that the separate corporate status should be respected and that it, the state-owned entity, and the state should not have to bear each other's liabilities. It would take extreme circumstances to be able to displace this presumption. This very high threshold that you need to cross to be able to have recourse to a state's assets when you have a debt against a state-owned entity is one which has been recognized in the English courts. So what this effectively means is that when you have a good arbitral award against a state-owned entity, it is often not easy for the state-owned entity to displace and to try to say, you can't execute this award against me because I'm an organ of the state and I'm immune from execution. I think that such an argument by the state-owned entity would likely fail. What then are the other strategies that a state-owned entity may then employ to try to disrupt or derail the enforcement and execution of an arbitral awards. I think this was something that was briefly touched upon, and we would know that there is an entire litany of strategies that can be deployed. It includes trying to set aside the award. It includes parallel proceedings all over the world. It includes re-litigation of matters, and you would have heard from the inaugural session when Justice Prakash spoke about the Deutsche Telekom and India case, where she says the doctrine of transnational issue estoppel applies to prevent a losing party from re-litigating matters which it has litigated and lost in the seat court, in the enforcement court. And it also entails, beyond that, various domestic court proceedings, legislative regulatory amendments, criminal investigations, all tactics and measures that we have seen certain state-owned entities, when faced with an unfavorable award, may employ. And this is something which we must be alive to, because it then brings us back to the very point that it is very important right at the time of contracting, knowing that there is the possibility of difficulty in execution, bearing in mind that much, if not most, of a state-owned entity's assets would be in the jurisdiction of its own domestic courts, and therefore you bring yourself back to the domestic courts, that you need to consider in your contracts with state-owned entities whether is it possible, not just while we have arbitration, we have the courts, but to incorporate more self-help remedies, which do not require you to have to run to the court, run to the arbitral tribunal to get such relief, and to see whether that helps with overall the effectiveness of measures against a state-owned entity. I will stop here and thank you very much.
Thank you, Ms. Yen, for sharing your thoughts. Now we'll take questions from the audience, but we'll just restrict it to two. Mike. Yes, ma'am.
My question is to the learned Solicitor General. Sir, you spoke about the Vivad Se Vishwas scheme for the procuring entities and the contractors to settle the amount. If I've gone through that scheme very carefully, Section 14 says that the procuring entity will verify and evaluate the dispute and then give an offer to the contractor. In contrast to that, Section 19 or Clause 19 of that scheme says that if the award is under 500 crores, then the procuring entity has to settle the amount. So according to me, there is a slight inconsistency between the two clauses of the scheme. How do we reconcile that? Is it mandatory for the procuring entity to pay the award once they've adopted the scheme?
So I have not examined it from that angle, but if what you are saying is there, it needs to be reconciled, and I can assure you that I'll bring it to the knowledge of the concerned ministry. It would be clarified.
Thank you,
if
sir.
there is any clarification necessary.
Thank you, sir.
Yes, the gentleman there, please.
My question is to the Solicitor General and a follow-up question to Ms. Cohen, Mr. Pilbrow. Sir, you mentioned about the appellate arbitration procedure being considered, but considering that Supreme Court has already approved the same in Cento Trade, so is the government looking to make legislative amendment or just the amendment in the arbitration clauses would do? And the follow-up question is, how is the international community going to react to the two-tier arbitration clauses, considering that lots of commodity exchanges have two-tier arbitration clauses?
What I said was that this is the thought process going on in the minds of those who are involved in the decision-making of public sector undertakings. Government is not contemplating any of these ideas. There is a thought process that there can be one full-fledged appeal which gives them the confidence that all our aspects were considered on the validity of an award. Government is not contemplating any of these things as of now.
The second part of the question pertains to the how is a two-tier arbitration clauses taken by the international community, considering that lots of commodity exchanges have two-tier arbitration clauses?
Please repeat the question. It's not clear to Mr.
My question is that Supreme Court recently approved two-tier arbitration clauses, Supreme Court of India. So my question is, how is Singapore or UK, what's their stand on two-tier arbitration clauses generally? Is there any precedent where they would have struck down? Or
I think generally Singapore takes a very pro-arbitration approach. So we would uphold arbitration agreements. That is the philosophy that we have. And I think UK and most of us share that same philosophy.
The UK view on would be very similar. It's very pro-arbitration as a jurisdiction, so they would look to uphold arbitration clauses wherever possible, certainly.
thank you.
I've been given to understand we can take 2 more questions, and I see the young girl there. She is interested. Right there, the girl.
Hi, my question is to Ms. Swee. I really like the argument that was mentioned in the case that a state-owned entity may not necessarily be a state. So once this argument is accepted at the award stage, what if later the state-owned entity goes is liquidated or is taken over? Can then a claim be maintained against the state to enforce the award?
I think when it comes to a situation when the state-owned entity is liquidated, you would then submit the proof of debt in the liquidation. So the liquidator would then do the necessary, pari passu and observe those principles of distribution. The thing is that once you have a definitive decision where the state-owned entity is not regarded as an organ of a state, you would have great difficulties to try to enforce against the state assets. So in that sort of situation, as an advocate, I will always try to see whether there are any other jurisdictions in which potentially the assets of that state-owned entity may be found, maybe not necessarily in the place of incorporation, and see whether there's possible recourse there.
Thank you.
Just pass on the, thank you.
My question is to Mr. Tushar Mehta. It's pertaining to the trust deficit which you've talked about, which some of the PSUs have, and regarding arbitration, like they've incorporated either accepted clauses in the contract or no arbitration clause. What can be done to overcome those trust deficit relating to arbitration? Overcome the trust deficit relating to arbitration.
I didn't use the word trust deficit. There are certain issues which do create a little apprehension, especially because of the lack of level playing field. And it will have to be debated, discussed, what will be the after effects of the solution, if at all there is any solution. So this is just an issue which was flagged, not that there is any solution in mind right now. This is what they feel right now.
Thank you.
Could I just add a point to the question before, the one that you raised about when the assets are liquidated, what might be the situation? I agree entirely that prima facie answer is that your claim is against that state-owned entity, so if its assets have been liquidated, then you are simply left proving in the liquidation. I have come across cases there where you then potentially have a claim against the state for the liquidation. I mean, it's a high burden. You're going to have to prove that the state has chosen to liquidate that state-owned entity for the purpose of avoiding that debt. But if you can meet that, then you have a claim against the state for its wrongful actions in liquidating the entity. So it may not be the end of the road. It's just a different claim than against a different entity precisely because, as Swee says, your claim against a state-owned entity is restricted to a claim against that entity. So it may not be the end of the road, but it is yet another battle to take on at that stage.
Thank you. I thank all the panelists for such an enriching session. With this, now I'll request Honorable Mr. Justice Prasad to please come onto the stage and felicitate the speakers. A huge round of applause, please. Shouldn't stop. Thank you, sir. We'll now take a 10 minutes break and we'll be back for the next session. Thank you.
Radhika, just one.
Yes, sir. Please, sir.
No, nothing. We picked up a lot of metaphors from the sports arena. Tushar Mehta spoke about a level playing field. At the end, all I want to say is to the team Bhakru, very well done job, I must say. And the Delhi High Court, very well done.
Thank you, sir.
She's on the way, making her way down. Because it's sorry about that. It's very, I'm very honored to be part of this very distinguished panel. It's
Just to click a picture of all of you, but just step forward.
Thank you so much.
Thank you, sir. Thank you. Very glad I have continue to see each other through the rest of the year. Sometimes legitimate claims 50 crores, 500 crores, 250 crores is the worst. And then you're in court in 34 within a week of court. That's the challenge.